Hello, in this presentation we will discuss about patent claims. Components of a patent document. If you see a patent document, various parts of document you will find bibliographic details with inventor applicant name, application number, patent number, priority date, filing date, grant date, title, abstract. They are all bibliographic details which you will find on first page of patent document. Next part of patent document is specification or description, in which you will mention about field of your invention, to which field your invention is related. Then you will describe background art or prior knowledge or prior references related to your invention. You will describe about prior art, the disadvantages of the prior art, and then you will describe your invention in summary, wherein you will mention the advantages or benefits provided by your invention over prior artwork or prior references. Then you will describe your invention in detailed description section. The next part of patent document is drawing. If any drawing, you will mention the drawing section. Then last part or component of patent document is claims, which is most important part of patent document. Claims define the legal boundary of protection. So in this presentation, we will discuss about claims. Patent claims. Claims in a patent are most important component. Claims define the scope or legal boundary of invention. Pre-grant importance of claims. The language of claims will determine whether a patent will be granted or not. So whatever language you use in drafting your claim, that language will determine whether you will get a patent or will not get a patent. So if you draft very broad claim language with broad claims, that may lead to rejection of your patent, because those broad claims in claim section may be anticipated by prior reference or prior art, and you may not get the patent. If your claim language is very narrow in scope, then that will limit the scope of the claim. So scope will be less because claims are narrow. So you have to be very careful while drafting the patent claims. Post grant importance of patent claims. The patent validity and patent infringement, they are determined by courts on basis of claims. If somebody files case challenging the patent validity, then the court will decide whether patent is valid or not valid on the basis of claims. Similarly, in patent infringement case, where the patent holder is alleging the infringement of his patent, so in that case also the court will decide whether patent is infringed or not infringed on the basis of the claims. Also, the patent maintenance fees which is to be paid to maintain a patent is also determined by number of claims. So lesser number of claim will be with lesser fee, higher number of claim will be with the higher fees. So again you have to be careful to draft the only number of claims which are necessary. If you draft very high number of claim, that will lead to the higher cost. The fee for maintenance of patent is to be paid at 3.5 years, 7.5 years, and 11.5 years after patent grant. So 3 times during patent life you have to pay the fee. If patent fee is not paid within these due times, then patent will lapse after 6 months. So if you are not paying the fee at this time period, then patent will lapse. And if once the patent has lapsed, then anybody can use that invention. Then patentee cannot file the infringement suit or infringement case if the patent has lapsed because of non-payment of fee. Usually, the owner of patent prefers broader patent claim in order to prevent market entry of similar products, in order to reduce the competition. He wants to have the broader claim. But ultimately, the patent granted claims will determine the extent of market power of patentee. If the granted patents are broad, then there will be high market power. If the granted patents are narrower in scope, then the market power will be less. Now, types of patent claim. Broadly, two types of patent claims: independent patent claim and dependent patent claims. Independent patent claim, as the name suggests, they are independent. They are not depending on other claims. They are standalone. They are self-contained. And the independent claim, they broadly cover the invention on which patent is desired. So the main invention, the independent claim, they claim the main invention, the broad claims for the invention. There can be many independent claim in a patent. So it all depends on the patentee, how many independent claim he wants to draft. Again, depend on type of invention also. So there can be one independent claim, there can be more than one independent claim in a patent document. And the independent patent claim are always broader than dependent claim. The scope of independent claim is broader than dependent claim. Second type of patent claim is dependent claim. Dependent claim, as the name suggests, they depends on other claims. They are narrow in scope than independent claim. The dependent claim, they generally express particular or specific embodiment or specific part of invention as fallback position. Fallback position because the independent claim, they claim very broadly. Maybe they are claiming a structure, very broad structure, which will include maybe 4 or 5 products. So that is very broad in nature. The claim is very broad. But what the patentee does in the dependent claim, in dependent claim, the patentee narrows down the scope of coverage. Now he is narrowing the scope of the claim structure to narrow structure, which may be covering only one specific product, not 4 or 5 products, only one or two specific products. So narrowing down the scope of coverage. So that's why it is called fallback position. Suppose a patentee thinks that if the independent claim, which is very broad in scope, if that is rejected, then what will happen? So at least he have some other claim which is not so broad but narrower in scope with specific compound or specific structure. So that may be granted. That's why it is fallback position. Fallback position because if independent claim is rejected, it is having at least one or more dependent claim which are claiming narrow structure or narrow coverage. Dependent claim may depend on a single claim or more than one claim. So it depends on nature of the product and the way the claims are drafted. Dependent claim are construed or interpreted to include all limitation of independent claim. So whatever limitation are there in the independent claim, they will come to the dependent claim also, on which they will come in the dependent claim because they are depending on independent claim. So whatever limitation are there in the independent claim, they will be there in the dependent claim also. So if you see the actual patent document, the you will see that claim number 1 is independent claim. Claim number 7 and 8, green highlighted portion, are dependent claim. So claim number 1 is very broad. It is not depending on any other claim. So that's why it is independent claim. Claim number 7 and claim number 8, they are depending on claim 1. So that's why they are dependent claim. So if you see the claim number 1, it is claiming method of making simvastatin comprising steps of combining together monocholine J and acyl thioester. So combining two chemicals together, they are making simvastatin. So they are claiming the method of making simvastatin by combining these two chemicals. So it is these two chemicals which are used for making simvastatin. They are very broad in scope. They don't have any limitation, or they are not limited to any specific property. But if we read the claim number 7, it says that method of claim 1, wherein the acyl thioester, the second chemical which is used to produce the simvastatin, is selected to possess at least one of the following properties. So in this claim, the patent is narrowing down the scope of the second chemical, acyl thioester, to chemical with two specific properties. In claim 1, there is no limitation. They are covering this second chemical very broad without limitation, but they are narrowing down the scope of the second chemical to two specific properties. So this claim number 7, which is dependent on claim number 1, is narrower in scope than claim number 1, which is independent, which is broader in scope. Same is with the claim number 8, which is dependent claim and which is depending on claim number 1, independent claim. Now coming to components of patent claims, so, or parts of patent claim. Basically, if you read the claim, you will find three parts: preamble, transitional phase, and body. Let us understand with an example. So example given below is a claim which is claiming a composition for treatment of hypertension comprising of administration of losartan and amlodipine. So in this claim, preamble is a composition for the treatment of hypertension. This is the preamble part. Transitional phase is comprising of, and whatever comes after comprising of is the body. So body is administration of losartan and amlodipine. So these are three parts. So whatever comes before transitional phase is usually preamble. Whatever comes after transitional phase is body of the claim. Now if you see in actual patent document, you can see all three parts of claim. If you read the claim, a method of treating breast cancer in a mammal comprising administering to said mammal an amount of compound of formula 1 or a pharmaceutical acceptable sort thereof. So here part before comprising is preamble. Comprising is a transitional phase, and whatever comes after comprising is body of the claim. Now coming to claim definiteness requirement for patentability. So there are different requirements for getting a patent or patentability. I explained it earlier in some earlier presentation that the basic requirements for getting patent or patentability are utility, novelty, non-obviousness or inventiveness, and fourth is detailed description or written description. And within the written description, you will find best mode, enablement, complete disclosure, and last is claim definiteness, in which uh, I have mentioned that claims which you draft in a patent document, they should be precise, they should be correct and clear. They should be non-ambiguous. There should be no ambiguity in the meaning of the term and language of the claims used in claim. So the claims must clearly point out and distinctly define the mates and bounds of subject matter that will be protected. So you have to mention your subject matter which you want to protect in a very precise, correct and clear manner, and your language should distinctly define the bounds or mates or bound of the subject matter, and should clearly point out to what you are claiming. Claim must set for the subject matter that applicant regards it as an invention. The meaning of various terms or transitional phases used in claim should be clearly defined in specification. The meaning of various terms which are used in claims, you need not define in the claim section itself, but you have to explain the meaning of these terms in specification or description section. So whatever you are mentioning in the claim section, it has to be described in the specification section also. And in specification section, you have to explain these claim in detail. You have to explain the meaning of all the terms which are used in the claim section. So your claim should be supported by specification. The specification part should support your claim, or claim language which you are mentioning in the claim section. Any unconventional meaning or other than conventional meaning of a term should be clearly defined in specification section. You can use any term in the claim and you can give any meaning to that term, but whatever meaning you want to give, you have to explain meaning of that term in specification or description section. Claim language in light of specification should reasonably define the boundary of invention to person of ordinary skill in art. Means the claim language which you are using in the claim section, which claim language should in light of specification. Claims are always interpreted in the light of specification or description part. So any explanation which is you want to find out about the claim, you have to check in the description section or specification section. So claim language in, that's why it is called claim language in light of specification. They are always interpreted in light of specification or description part. So claim language in light of specification should reasonably define the boundary of invention to one person of ordinary skill in the art. So person of ordinary skill in the art, after reading the claim language, should understand that what is the protection or boundary of protection of invention claimed in this patent document. And the person of ordinary skill in the art is person who is skilled in that field of invention. Like in case of chemical invention, a person usually with graduate degree in chemistry or chemical field will be considered as a person of skilled in art in chemistry or chemistry field. Now coming to patent claims drafting guidelines, because claims are most important part which define the legal boundary. So you have to be very careful while drafting the patent claims. So all the scope of protection of your patent will depend on the language of your claim which you are drafting. And there are certain guidelines you should consider while drafting the patent claims. Each claim must be a single sentence. You read any patent document, read any claim. In each claim, you will find a single sentence. The full stop will come at the end of the claim. So in a claim, you will not find two sentences. Whatever length may be of the claim, you have to write in one sentence. You'll see in certain patent document a single claim is running in maybe in 2 pages or 3 pages, but it is always as a single sentence. You put comma, you can put comma in between whenever required, but you cannot put full stop. So a claim must be a single sentence. If you draft broad claims or broader claims, that may make the grant of patent difficult, because if you are drafting very broad claim, then granting of patent may be difficult because of possibility of anticipation of your broad claim by prior art or prior references. So it may not be granted in light of prior references. And if you draft narrow claims, then they may be granted if not anticipated by references, but they will limit the scope of the protection. So narrow claim will have narrow scope of protection. They will be covering or protecting very narrow part of your invention, and as a result may not provide good commercial attraction for the invention. Therefore, claims should be drafted in such a way as to cover all potential commercial features of your invention and yet not anticipated by prior art. So it should be as broad as possible so as to cover the potential chemical feature, but it should not be too broad that will be anticipated by prior art. So you have to be very careful while drafting the claim. All subject matter in claims should be described and supported by specification. As I mentioned earlier, whatever you are mentioning in the claim, it should be described in the specification part also or description part also. All the claim language has to be explained in detail in the description section, and the claim should be supported by description section. That's why subject matter in claim should be described and supported by specification section or description section. Any unconventional meaning of term used in claim should be defined in specification. As I mentioned earlier, you can give any meaning to any term used in your claim section, but you have to explain that meaning in the specification or description section. The last 3 points are basically they are not related to claim, but they are related to the patent itself because they are important. That's I have mentioned them here. The background art section should also be drafted carefully, because this section will educate the examiner about problem solved by your invention. If the examiner understand the problem solved by your invention clearly by reading the background art section, then you will be able to understand your invention correctly and perfectly, and it will help in the examination of the patent. So you have to be careful in drafting the background art section also. Inventor is not required to describe the theory underlying the operation of invention. So he need not to mention the detailed theory behind the invention. He has to basically mention but he has to mention the invention in detail, the practical part. All detail he has to mention with examples. And drawings can also be used to describe the prior art. Instead of using the text, somebody can also use the drawing to explain the prior art related to the invention. So in this actual patent image, you will see the example of how the claim should be a single sentence. Each patent claim must be a single sentence. If you read the claim number 1 or any other claim, you will find it will be a single sentence only as a single sentence. Full stop will come in the end of the claim. So that's all in this discussion. Thank you very much.